Good afternoon, students. This is Professor Martin. Welcome to lecture again. This is going to cover a little bit past what we last talked about in terms of Congress. Wanted to move on a little bit now to the presidency, second branch of the federal government that we will be covering. Obviously, in this unit, there's a lot to play with. Now, to a certain extent, that's a feature of contemporary life. Once upon a time, you didn't have as nearly as prominent a role for the president and as visible a role for the president. But I think there is some continuity between what the president has been authorized to do from the beginning and also the kinds of things that the president has been authorized to do and has done in the present. Now, just a couple of things I'd like to take care of this particular section. I want to go over a little bit of the different sources of the president's power, some of the sources of congressional power that can be used against the president, and also some of the historical occasions on when the use of that power has been questioned by more than one branch of government. Hint, this usually is the case during war or affairs of national security. But in any case, sometimes the most important questions that a president needs to be asked is how much can you trust them? And what kinds of power are you willing to give them? Because to a certain extent, the president is only as good as the amount of trust or the amount of authority that they are given. And so we want to try and unpack is where does that authority come from and just how much trust do the branches of government and those in the United States citizenry as a whole actually give it to them. In terms of the presidency itself, it's become much more of a people's presidency over time, which is to say a bit more representative. It used to be something that was very much your stereotypical sort of backroom deal, smoke-filled backroom deal in terms of how someone was picked to run. Gradually, that morphed into what they called the caucus, which was much more of a party-based kind of way of picking, to the formats, including caucuses and primaries, that you see today. So, to a certain extent, the presidency has become more your quote unquote presidency, but regardless of how popular the choice has been, some of the things that the president has done will remain the same. There's 5 separate categories of duties that the president is going to perform according to Article 2 of the U.S. Constitution. So please go ahead and if you have something at hand to write with, take these down now. 5 basic duties. The commander-in-chief, the enforcer-in-chief, so to speak, of the laws, the diplomat-in-chief, which is to say the one person who speaks for the country abroad, the CEO of the government, which is to say the person responsible for the administration of the executive branch day to day, and 5 various legislative duties. Of these, we've talked a little bit about the legislative duties before. In other words, the kinds of measures that the president can sign or that the president can, in 2 different forms, veto. These others, though, I think are worth unpacking a little bit more. When we look at the powers that are going to be ascribed to the president, it's important to note that both in the Constitution and in practice, there tends to be a difference in what are called expressed powers, which you would probably say is exactly what is on that list of items in the second article of the Constitution, delegated powers, which is really more along the lines of what happens when Congress gives the presidency certain kinds of powers in order to accomplish something, and certain things that are, well, they're not exactly on the list, but you kind of assume that they're inherent powers. Usually, in terms of national emergency, there are certain things that you would just assume a president should be able to do. Now, to a certain extent, this is something which is going to have certain perks that the president has in carrying these duties out. Some of these are obvious, some of these are not so obvious. We will discuss in greater detail what is called an executive order and executive agreements, but in any case, suffice to say for the moment that those are ways in which the president can engage in either acts directing the executive branch to do something, or in the case of executive agreements, arrive at an understanding with a foreign power in ways that do not have to technically be subject to congressional approval. Another prerogative that's also worth noting when we examine the question of what can the president have access to that the Congress does not, a lot of that will come under the heading of executive privilege. Executive privilege is kind of an obscure term that you may not run across all the time, usually only in context of some kind of potentially damaging information or scandalous information that Congress wishes to get their hands on and that the president does not wish to provide. One of the big examples in recent years, for example, has actually come from the confirmation of justices for the Supreme Court. Justice Brett Kavanaugh, if you remember from a few years ago, had a great deal of controversy surrounding his particular nomination, part of it having to do with, as we spoke of before, his personal life, but also to a certain degree, what were the finer points of how it was he was going to rule on various kinds of cases. And so there was a desire on the part of the opposition, the media, to see if they could find anything in his records, his case opinions, and things like that, that indicated anything about how he would rule. However, what immediately happened was that President Trump basically classified and withheld all those records on and from Justice Kavanaugh so that the press and the opposition in Congress could not read them. And the argument, therefore, being executive privilege. These are, in his words, documents that are directly related to the informing the president's choice of who it is to choose for that position, and therefore they should not be for popular consumption. A lot of his critics at the time said this was just a way of hiding anything damaging that might be said about Justice Kavanaugh. But it's a sign, I think, of the ways in which that particular kind of tool is used. It can be used in a fairly sensitive way and sometimes a very partisan way. In terms of an executive agreement, which just got mentioned, not to dwell too long on it, but I think you might want to take a look. If it's mentioned in your book, I think it might have been a little, but in any case, maybe Google it just to get some further details. An executive agreement in the form of, say, President Obama's opening to Cuba, reopening the U.S. Embassy there, having public level talks with the Cuban president. In these cases, these were not approved by Congress at the time. Republican legislators, particularly in Florida, who represent the Cuban community, were very unhappy with the president for going this route. But the president felt that, as a prerogative of him being diplomat in chief, this should be something he should be allowed to actually engage in. And also, although not making a new treaty, obviously the United States and Cuba are not going to be friends, quote unquote. He nonetheless felt that he could initiate something of a breakthrough that way, in a way that did not necessarily involve Congress having to approve any treaties. Now, these are some of the prerogatives of presidents, and some of them can be very broad indeed. However, I think it's also worth mentioning the tool of impeachment, which we did dwell on a little bit earlier this year prior to our present online status, especially in regard to, as you well know now, President Donald J. Trump's impeachment in the House, but he was not removed in the Senate. Now, unpacking this a little is probably a good idea, just because each of these cases has features which are unique, but there is a bit of a thread to them. There have actually only been, prior to President Trump, two presidents that were impeached, and you can probably guess who they are. Well, in one case, President Andrew Johnson, who was not a very radical Republican at a time when the Republican Party under Lincoln and afterwards had become much more radical in the sense of abolitionist, in the sense of wanting to punish the South after the Civil War, and he was much more moderate. He eventually was so much so that on a charge that was probably about as mild as you could possibly get, they used that as a pretext to try and impeach him. They did impeach him, and he was almost removed from office in the Senate by, however, one vote was missing. You can remove someone from office in the Senate after they have been impeached, but you need a two-thirds vote of the senators to do so. That's particularly important because every case that you've seen thus far, when someone has been impeached and the actual person impeached has been tried for removal from office in the Senate, none of them has ever been removed from office that way. And that question of do they have enough votes in the Senate is the big reason. But I think the tale of Johnson you can probably extrapolate a bit to the present. Bill Clinton 20 years ago was an interesting case. If you don't know anything about Bill Clinton in this particular instance, there are a lot of conspiracy theories that have surrounded his presidency, some for good reason, but the most obviously provable ones had to do with his indiscretions with women, apart from his wife. The one that arose in 1998-99 was a case where he was asked about a prior affair with an intern at the time in the White House, Monica Lewinsky, a name you may have heard. And the critical question there was not necessarily the affair, although the details for this were rather lurid, but the fact that when he was initially asked about this, he did not tell the truth about their relationship under oath. So it was not necessarily the time that the affair was what got him in trouble. It was more so the lying under oath, perjury, that got a lot of attention, perjury and obstruction of justice. Incidentally, if you are curious and you would like to find out more about this case, the details of this came out in something that was called the Starr Report, named after the congressional investigator Kenneth Starr, independent counsel who released a report detailing all the interviews and facts that they accumulated about President Clinton's relationships, including rather graphic depictions of the two of them performing various sexual acts in different forms of the White House, including one while the president was on the telephone. Now, obviously, this scandalized an entire country, but after a while, you had a situation where the support for impeaching and removing the president was not there. And you saw that to a certain degree the following election when the opposition party raised the specter of seats that they lost because of their involvement in this. So I think what you're seeing here is that the charges for which some of these people have been impeached have not necessarily been that large. They're procedural ones or they relate to personal peccadillos. Now, in the case of President Trump, that's a little bit of a different story. Insofar as I think you're familiar with the broad outlines of where that story originally came from, how it alluded to presidential pressure on a foreign government to find out dirt on the president's possible opponent in the upcoming election. But nonetheless, seems to be, for the most part, this is a tool that is not successfully used very often or has not been to this point. And it's also something that seems to be a very partisan kind of tool. That's probably one of the reasons why the founders made it such a high level of votes to convict them, and therefore not wanting to see this used as often as might be.